Crossroads. I'm Curtis Valentine. I'm director of the Future Learning Network here at the Progressive Policy Institute in our Reinventing America Schools project. Today's event is co-sponsored by the 74. Our project promotes a model of schools we call 21st century systems, or systems that promote, provide parents more choice, give schools more autonomy in return for more accountability. Our project shows that public school systems that do this produce the most rapid improvement in student performance. Today's webinar will discuss the implications of the recent Supreme Court case regarding the legality of funding charter schools founded by religious institutions with public money. We've assembled a rock star panel of experts who have been following the case rather closely. But before I introduce them, I want to survey who's in the audience. So as you see this survey come up before you, we'd like you to answer the question as follows. What group do you most identify with? As a parent, educator, funder, journalist, advocate, or policymaker, specifically on this topic? If you're like me, you fall into multiple categories. But as it relates to this particular case and the state of education in this country, what group do you most identify with? As you're answering that, I'll allow my esteemed panel to introduce themselves. And so we'll start closest to me, literally down the hallway, and we'll have Rick Kallenberg introduce himself.
Hi, thanks so much, Curtis. Great to be with everyone. My name's Rick Kallenberg, and I'm director of the American Identity Project at the Progressive Policy Institute. The project is aimed at trying to teach kids what they have in common as Americans. Thank
you, Rick. Good to see you. Jason.
Hi there. I'm Jason Zora. I'm the Director of Federal Policy and Partnerships for NACSA. That's the National Association of Charter School Authorizers. It's a membership and advocacy organization for charter school authorizers that oversee charter schools across this country.
Thank you, Jason. Glad you can join us. And Eric.
Hey, Curtis. Thanks for having me. Eric Paisner. I'm the Chief Operating Officer of the National Alliance of Public Charter Schools. And we're a national organization committed to advocating for more high-quality public charter schools across the country.
Thank you, Eric, for joining us. So before we get started, let me just see the results of that survey. For those who are here. So we have about 40% of those in this space are advocates for education. The second largest groups are educators, and the third are policymakers. So fellas, you all see that. You can kind of get a sense of who's listening in, and as you're sort of answering your question, understand that folks who are here are people who are paying attention because they want to do something, and they want to impact this in some way, shape, or form. But before we get into the questions, I want to just sort of ground us in sort of how we got here. So 2 years ago, the state of Oklahoma's Charter School Board approved an application by the Archdiocese of Oklahoma City and the Diocese of Tulsa to establish the St. Isidore of Seville, a virtual Catholic charter school. To be clear, Oklahoma state law governing charter schools requires them to be non-religious in their programs, admissions policies, and other operations. That being said, the state board's contract with St. Isidore provided the school could freely exercise its religious beliefs. I want to come to you first, Eric. The National Alliance for Public Charter Schools has been following this case closely and been proactive to ensure that public charter schools remain public. Summarize the key aspects of this case as you see it. But before that, for the audience's sake, please explain what a public charter school is and why we have so many of them in this country.
Sure. Thanks, Curtis. Well, first, starting with a charter school. A charter school is a public school. Charter schools were first created a little more than 30 years ago to provide new public choices for families. They are independently run and operate separately from district-run schools. The schools are still required to uphold state standards, and all the students take the state tests. The key differentiator here, some of the key differentiators that individual groups apply to authorizers to open the schools, and they must be granted that authority, usually by a state or a district. Charter schools have more autonomy to operate, and in exchange, they're held to heightened accountability. The idea is that these schools provide something different for families who have not always had options for their children. But if the schools don't perform, they can be closed down according to the contract under which they operate. But as public schools, they are free, public, and open to all. So switching to the case, to your second question. So as Curtis mentioned, for the first time, a group applied to open a fully religious charter school. That had never happened before. In all 47 states where charters are permitted, the law says that they need to be non-sectarian. Because they're public schools, charter sector has always operated with the belief that they can't establish religion. That's just a part of what we understand from the US Constitution. In this case, St. Isidore's was hoping to open and operate, but as a Catholic school, and it has challenged that principle that we understand under the Establishment Clause. It's argued, in fact, that it's a private school, a private organization, and as such, the Establishment Clause, which limits what government can do to establish religion, it says it doesn't apply. And instead, the group is arguing that to deny the school and those individuals from participating, from opening the school, it's a violation of their free exercise rights. That's another provision of the First Amendment. So these two provisions are somewhat in question here as it relates to this case. They're asserting that if charters are available to a whole variety of groups, that prohibiting only religious schools, only religious groups from participating is discrimination. But we at the National Alliance and with our coalition partners believe that these are public schools and they just simply cannot be religious. So it's not a comment on the value of religious education or on other programs by which funding can go to religious schools and other groups. It's just based on our fundamental understanding here over more than 30 years that charter schools have been public in all places since their founding.
Thank you, Eric, for again outlining sort of what charter schools are, why this case is so important. But let me just double back a second, and I want to reiterate this question. Why are charter schools in such demand throughout this country, where in some places you have waiting lists? Like what about this particular model is attracting people to these schools?
Yeah, for sure. And it's a great question. I think, first of all, what we've seen over many years, and particularly coming out of the pandemic, it's become very clear that parents are clamoring for all sorts of options for their kids. I think they've just seen that the sort of model that we have seen over decades and decades just doesn't apply for all students, and they're looking for customized and different types of ways that their children can get educations in a way in which they meets their individual needs. So we've seen that the demand has been consistently high, really in state after state for now more than 30 years. But we're also seeing that charter schools are successful. Research is showing that in many places, particularly in cities across the country, we're seeing that charter schools are outperforming their district counterparts. So charter schools are working. They're working for families, and families want choices. They can see that their students and children can be successful in lots of different settings, and they want that for their kids, just as families with means have always had. So it really shouldn't be surprising that charter schools are in such demand, and even now, and they continue to be in significant demand.
Thank you so much. Jason, I want to come to you because at the center of this case is the Oklahoma State Charter School Board. And I'll just be honest with you, I served as a charter authorizer for 10 years as a member of my school board. I'm actually wearing a pin for Legends Charter School that I helped authorize, Financial Literacy Charter School. Just parenthetically, their funding for a grant they had with AmeriCorps is in question now. And so these are hitting schools rather quick. I just want to put that out there. But the Oklahoma State Charter School Board functions as a charter school authorizer. And it approved this virtual charter school in question based on the power they have to do so given to them by the state of Oklahoma. So Jason, the National Association of Charter School Authorizers was founded on the beliefs that America needs to provide better schools, better public schools, specifically to more children, and that charter schools should play a vital role in providing those better public schools. I'd reiterate public schools. For the audience and for the purpose of this conversation, what is a charter authorizer? And why was this case of such concern to your organization?
Yeah, thank you, Curtis, and thank you for having me and hosting this discussion. So a charter school authorizer, in simple terms, is it's the entity that reviews a charter school application, approves or denies that application, and then once approved, oversees the school and importantly renews or revokes the charter. So they are the entity that is overseeing the school, that allows the school to come into being, is overseeing and monitoring the school, and ultimately has the authority to extend that school, renew its contract, allow it to continue to exist, or revoke that contract, or in extreme cases, terminate that contract before it comes up to renewal too. So the authority to say yes or no, this school can open, the school can continue to operate, or the school has to close and can no longer serve students and access public funds. The vast majority of authorizers in this country are, without a doubt, public entities. I don't have the specific the numbers in front of me, but the vast majority are local school districts in countless states. In many states, local school districts are the only or the predominant authorizer, or state education departments, or in a handful of states, a standalone state agency that we call independent chartering boards, that act effectively as a state level agency, and typically are either overseen by elected bodies or appointed individuals from the governor or from the legislature, or public colleges. There's a very limited handful, and only in a few states, where authorizers are not explicitly what we would consider a public body. A handful of private colleges, a handful of nonprofit organizations, but those tend to just be in a few states. I believe Minnesota and Indiana are kind of the two predominant ones. And notably, in those states where authorizers may not be, where there are more authorizer types and they may not be explicitly public agencies, there's a really ramped up involvement from the state agency in overseeing those authorizers. So in states like Minnesota and Indiana, like I mentioned, the state plays a very important role in overseeing the authorizers, who are then overseeing the charter schools. Just kind of a lay of the land of who authorizers are in this country, and that how connected they are to the state. And as you kind of mentioned, one important thing to think about and remember with this case is the case the Supreme Court heard is actually two cases merged together. There was the case, the Oklahoma Attorney General brought suit against both the school and against the authorizing board, as you mentioned here. So there's the actions in question are both the school and the authorizer in approving that. The authorizer and the actions of the authorizer, in our opinion, are vital to this whole case. A big question of the case is the approval of this school and allowing this school to exist. It could not exist without the action of the authorizer in approving that application and signing the contract. If you had listened to the oral arguments, a phrase that kind of kept coming up and was in the discussion was create and control. Basically, the question is, can this school exist without some entity of the state or some action of the state, of the government, creating and allowing the school to continue? And our position in this is very clear, and we made it in the amicus brief that we filed, is that the authorizer's actions are vital to creating that school. The school can't exist without approval. It can't continue to exist without being overseen by the authorizer, and the authorizer has the power to kind of shut that down at any time that it's violating the terms of that contract. So this gets to that one of the core questions that the court was wrestling with at our argument: is a charter school created and controlled by the state? And we certainly think. More broadly, and the reason that NACSA was filed an amicus brief in this case is watching it closely and is deeply concerned about potential outcomes of this case, because the potential outcomes put authorizers really in an impossible position going forward. If we project forward and say, religious charter schools are permitted, it basically makes authorizers' role in evaluating applications, in overseeing schools, in monitoring and evaluating schools, and making these hard decisions on whether or not to close a school effectively impossible. We kind of gamed out in our internal discussions with other things. We've gamed out theories of let's game out some possible circumstances. Let's say an authorizer denies a religious charter school's application. Essentially, they say it's on the grounds that it doesn't meet the authorizer's existing standards, the same standards that would apply to any other school. They say this school doesn't have a rigorous curriculum, or this school doesn't have a clear enrollment policy, which you would uphold to any other applicant. Now our religious charter school is denied, and they say, well, you denied us because of our religion, so you're violating our rights as a religious entity. I think you can see this coming up. It maybe in Oklahoma, where they approve a Catholic school, and a week later they deny a Muslim school or a Jewish school. It puts the authorizer in an impossible position. Same thing in overseeing and evaluating a school. How does an authorizer, say they approve a school, how does an authorizer rigorously evaluate religious education? How do they say, like, well, you're actually teaching Catholic doctrine? Or how do they deal with a school that refuses to comply with some of the basic requirements of a charter school, like conducting state assessments or providing special education services, if they deny doing those so and say that's because of religious belief ground? So in our opinion and why we're so invested in this case is because it puts authorizers and the work of quality authorizing in a really untenable position.
Thank you so much for outlining that. But also, again, in reiterating that most charter school authorizers are like myself and other members of the school boards around the country. For those who may not know, there are 15,000 school districts around the country. The majority of the members of those school boards are elected or appointed by elected officials. And these are public entities governing these public charter schools. I want to reiterate this: public. In many ways, that's why they're effective in so many places, because those parents are holding those officials accountable during elections and all the other period of time. But thank you so much. We want to go back to the audience again and ask you a very fundamental question, one that we've talked about already. Do you believe America needs to provide better public schools to more children, regardless of income or zip code? And again, with those of you who are wrestling with the question, again, do you believe that America, this country, based on what is founded and the promise that we've said to those who have been here and those who are coming, that America needs to provide better public schools to more children, regardless of income or zip code? And as you were answering that, I do want to bring in a colleague and someone who's written about this, but also has from different perspectives, and I think they're incredibly important. This is why we asked you to join us today, Rick. I personally firmly believe this case of this nature deserve more attention. You've given that attention in your writings. You recently wrote an op-ed in Slate. You have another one coming out. But in that Slate piece, you wrote something that caught my attention. I imagine might have caught some others' attention. You said that this case could yield the most significant legal decision to affect schooling in decades. I've heard since Brown. I don't want to sound too hyperbolic, but I know you were quoting other journalists, and these are not your words, but again, you put them in there. Why would you or anyone say something like that? That this could be the most significant legal decision to affect schooling in decades?
Yeah, that's a great question, Curtis. I mean, this is a blockbuster because if the Supreme Court rules that charter schools are private schools, it completely upends the idea of a charter school. These are schools that serve nearly 4 million students. Charter schools represent one of the biggest education reforms, if not the biggest education reform in the last 30 years. And they're premised on the idea that they're public schools. All 47 states that have charter school laws say they're public. The federal government says they're public. I'm going with your motif, Curtis. Public, right? I mean, it's so clear. And so if the Supreme Court rules otherwise, it'll have enormous ramifications. It's hard to wrap your head around this case because in so many ways, charter schools are very clearly public. There was a moment in the oral argument that really caught my attention when Greg Garr, who served as Solicitor General under former President George W. Bush, ticked off 8 reasons that charter schools are public schools. He said, private schools can open without any state approval. Public charter schools can't do that. There are no requirements for supervision or curriculum for private schools. There are for charter schools. Private schools can charge tuition. Public charter schools can't. Private schools can restrict admissions. Key issue. And public charter schools cannot. Private schools are not subject to the tests, the general state assessment tests. Public charter schools are. Private schools are not subject to nearly the level of reporting and oversight that charter schools are. Private schools are not subject to state rules regarding civil rights and school discipline and health. Public charter schools are. And then finally, there's no process for closing private schools, short of consumer fraud. And as Jason just mentioned, that's a key aspect of the charter school authorizers, to close down charter schools that are not doing well. So if nevertheless, despite all that evidence, the Supreme Court rules that charter schools are private, I think it could mean a couple of things. One is in blue states, it could mean that the appetite for new charters is lost. Existing charter school laws could be revised. When private school voucher initiatives have become before voters for private religious schools, they almost always lose. And that's because the public does not like the idea of public funding going to private religious schools, particularly in blue states. So I think there'll be a huge cutback in blue states. In red states, it's harder to know. It's possible that some of those charter school laws will be challenged because the state constitutions require that the money go to public schools. But if red states find a workaround, it'll still be bad because it means further balkanization. Public education, including public charter schools, is one of the few things that holds our society together. It's the common experience for 90% of American school children. And if you suddenly have, substantial numbers of Christian students going to their schools, Jewish students going to theirs, Muslim students going to theirs, that means that fewer Christian students come to know Jewish and Muslim students as classmates and friends. Our public schools are already highly segregated by race and class, and this would just layer on religion as a new source of balkanization. And I think it has profound implications for our democracy. If, I'll say hypothetically, someone runs for president and demonizes Mexican immigrants, that works in a society where people didn't grow up knowing Mexican immigrants as classmates in their schools. And with religious balkanization under this potential ruling, I think that'll just be one more source of division in our society. And again, provides opportunities for demagogues to try to demonize populations that people won't have met in public school.
Thank you, Rick. I don't know if I should thank you or not for that. I mean, it wasn't necessarily good to hear, and I don't want to think that this could not happen. I think over the last few years, we've realized the things that we thought couldn't happen are happening almost every day. I do want to get to our survey question. If you can pull that up, because we asked folks, do you believe America needs to provide better public schools to more children? And again, and the three words: better, public, to more. And we've talked about this idea of abundance, and wherever you are, you may have heard about this. But what we can say as a country is that we don't have enough schools serving our children with the quality of education they deserve and that we promised them. At the same time, I wanted to say this, even though I believe that this has not got the attention that it should have. There have been folks who have been fighting for this every day, going down to the Supreme Court, pushing for these things. Throughout this process of reviewing the case, a coalition of organizations and advocates were very active in ensuring the court understood the facts about charters, as well as the implications of all the decisions they could potentially make. And Eric, your organization was at the forefront of that. I just want to give you all credit. That coalition was led by a lot of organizations, but in very many ways, Eric, you are at the center of that, submitting an amicus brief to the court, similar to as Jason mentioned. What was the position of the coalition as your organization, but just in general? And what was the argument you tried to make in your brief to the Supreme Court?
Yeah, thanks, Curtis. And it really was a broad coalition, and we were, honored to be a part of it and to help try to pull folks together. But there really were just a wide variety of voices that stepped in here. So, we deserve some of the credit, but really, it's really a lot of voices that were speaking on behalf of the charter school sector, their families, their schools, and otherwise. And in general, the position of the coalition was that charter schools are public. And we wanted to talk about sort of the impact and the history of charter schooling. So starting with the history, it was really important for us and our brief and others to raise the fact that charter schools were created and always were created as public schools, just different kind of public schools. Actually, the first charter law passed in Minnesota in the early 90s, and a vocal supporter of charter schools at the time was Al Shanker, who at the time was the head of the AFT. I know, Rick, you've written extensively about Al Shanker. But the idea was that, these were different kinds of schools that wouldn't be run by the districts, that would allow for innovation, but they would be public choices. And one of the briefs that was filed was by one of the voices was Ember Reichgott Young, the original author of the first charter law in Minnesota, and a variety of other original legislators across the country and governors who the first ones to sign their laws into effect, basically saying these schools were always intended to be public. Now, as we were talking about before about charters being a little different, they don't always fit exactly, they don't check every box that we think about when we've thought about the way public schools have looked for 100 years in this country. It's by design. But it doesn't mean they are not public. And to echo something that Rick was saying about Greg Garr and the 8 factors of how charters are different than private schools. In the brief that the Oklahoma Attorney General filed with the court, I think they identified 37 ways in which the charter law was, very similar to the way in which other public schools were run in Oklahoma. So it's critical that we identified sort of the history of it and the elements of it. And as I said, the voices of the historians, could really show that. The other thing that we really wanted to articulate as a group was about the impact that charter schools, that if the decision was overturned, the impact that it would have on students and families, teachers, school leaders, and a whole variety of folks operating across the country. One of the voices, I think, NACSA, that Jason said, submitted a brief, and it was really clear talking about sort of how charters only come into life when they are, established by the authorizer. And that point was also sort of, echoed in lots of other ways. And then, if the case was overturned, you had a group of parents that said, these are the reasons why we chose charter schools, why charter schools are different, have been difference makers for our families. And this could only exist in this public school setting. There were a variety of schools, I think, that represented 180,000 students that said, we came into this as public schools. We operate as public schools. We accept all of the responsibilities that public schools have always had through the Constitution, through state constitutions and otherwise. There were state associations of charter schools from all across the country representing more than half of all charter school students saying the same thing. The charter laws in our states have always been public. They were designed to be public. So, and that if the case was overturned, they do not know, in particularly these state groups, what the law would foretell for how these schools are run. Charter schools have always operated as public schools and have been funded as part of sort of this general operational framework and funding mechanism that's provided in state constitutional mandates in nearly all states that say students are entitled to schools and we are required to provide public education for students. There are funding formulas, per pupil mechanisms that fund students in public schools in that way. If charter schools were declared to be private, then we don't know exactly whether those funding mechanisms and other operational supports would exist in the same way. So really, we wanted to make sure that the history and the impact was really articulated from a variety of different perspectives on behalf of tons and tons of advocates, educators, and millions of families across the country. And, we were during oral arguments, no less than 4 justices out of the 8 on the bench that day brought up the question of impacts, including Justice Gorsuch, who said, well, what's the boomerang effect of this? If, we understand this decision in Oklahoma, what happens in state by state for the other, nearly 4 million students across the country? So we know we reach them. We just hope that it's persuasive. So that was the coalition. I think that the coalition did a really great job of articulating why this is so critical for the charter school sector. There were a variety of other folks that also raised questions about sort of separation of church and state, and certainly arguments that Rick, identified later about the nature of education. There were briefs that talked about that as well. But on the charter piece, it really sort of about like the history of charter schools and the impact to the students in them.
Thank you to you and to Rick for outlining those 8. And Rick, I would add a 9th one. And I brought this up when I saw you last, Jason, is that these private institutions in some ways could also have a religious litmus test for their employees. And so the idea that you have to be of a certain religion to teach at the school is things that I've heard and seen in religious schools where you have to, they could decide your employment where you have to declare your religion in order to work there. Jason, again, last time I saw you in person, you did an excellent job to really explain there are different ways the court can go, different decisions, the voting and things like that. You outlined them really well, but also the impact it could have on state policy and how charter school board and others would have to respond. Take some time and walk us through the impact of each of the decisions, what it could have on public charter schools, but public schools in general, if you could.
Yeah, I'll do my best. Yeah, I think we as observers, and I think the kind of observers of this case, see really 4 potential outcomes for this case. And I'll lead out. I think it's important to note again that in this case, the court was addressing 2 questions. So they're kind of dealing with 2 distinct questions. One was, can the Catholic Church be excluded from even applying for a non-religious operated charter school? So the way that Oklahoma's law is written, the way the number of other charter school laws are written, is a religious entity can't even apply to hold, even if they're going to operate a fully secular charter school, they're prohibited from even applying to hold that. So that was question 1. Question 2 was then, assuming the first question, does Oklahoma have an establishment clause grounds for denying a religiously operated charter school? So very specifically, the school is operating in an openly religious manner, which is the case here. The school has made no qualms about they're going to have a religious curriculum. They're going to abide by religious church teachings. I think in their application, they noted they would provide special education services only to the extent that they complied with church doctrine. So they are very openly about that. That's not a question. So taking those 2 questions in consideration, we really see kind of 4 potential outcomes. 1, the status quo. The previous decision, that's the decision of the Oklahoma Supreme Court, is upheld. That would lead to the status quo. That would lead to, religious charter schools continue to not be permitted. Oklahoma's statute and others that are like that exclude a religious entity from even applying to hold a charter school, that's upheld. Important to note, one justice, Justice Amy Coney Barrett, has recused herself. So a 4-4 split decision would uphold the lower courts, or in this case, the Oklahoma Supreme Court's decision. Given why we assume that Justice Barrett has recused herself, and she hasn't gone on the record or say anything, but it's kind of assumed that because of her affiliation with the Notre Dame Legal Clinic that supported the school through this process is why she recused herself. It seems like maybe a 4-4 decision would probably just kick the can down the road a little bit. So, but that being said, either a 4-4 decision split or a 5-3 decision, if 2 of the more conservative justices flipped sides, would uphold the Supreme Court, the Oklahoma Supreme Court decision. Number 2, we could see a narrow ruling that addresses the affirmative for that first question. So ruling only on the question of whether a religious entity can be prohibited from applying for and operating a secular, a non-religious charter school. I think we would not be surprised by this. And there are a number of states that do permit this. I think Indiana is one where a religious organization can hold the charter school. But again, this kind of gets to what I laid out before, where it's important to remember the approval of the charter school application creates a new entity. So it's creating a standalone entity. The charter, the contract for that school is held by a separate entity, the governing board or the applying entity, but the school itself exists as a fully separate entity. So this could be a case where the holder of the contract is a religious organization. The school itself operates with all the other requirements, all the other restrictions that any other charter school, it's just governed by. And I think even in the few states where this does exist, there's examples where a Catholic diocese operates or holds the charter, it's in a formally Catholic building. They have to take down all the crucifixes. Any religious instruction can't occur during school days. There's examples where they pull down the crucifix in the gym, and then on Saturday they put the crucifix back up for programming, and they take it back down Monday. So it's a fully separate thing. So that is one pathway we can see, and wouldn't have too broad implications because this exists in other places and is operated. It doesn't change the role of the authorizer. Third, I'll kind of swing the other side. So third, we could see a broad ruling where you see kind of ruling in affirmatives on both those, and this would where explicitly ruling that charter schools are expressly not state actors and therefore permitting openly religious charter schools with unclear restrictions on how those schools could operate. This would, I think, kind of more importantly, open the floodgates to litigation. We would really see a lot of litigation, and depending on the scope and the specific language used in that decision, a lot of litigation about, well, what requirements can still stand up to a religious a claim of, well, this is our religious beliefs and therefore we don't need to comply with XYZ regulations. So you would probably have a lot of litigation into the area of what's a compelling state interest, what remains a compelling state interest that can supersede a school's religious beliefs. And you would probably end up with lots of litigation around enrollment policies, around curriculum and state academic standards, around testing requirements, around countless things where those two, where the interest of a religious entity and the interest of the state are butting heads, and we need to litigate, does the state have a compelling enough reason to overwhelm that religious entity? So that you're going to open up the doors to some religious schools, but you're going to open up the doors to a lot of litigation. And fourth, and this is the kind of the hardest thing to suss out, we kind of refer to more of a middle road ruling. It's hard to speculate what this could be, but this really depends on all signs pointing to Chief Justice Roberts being the pivot vote, and more likely than not, the one who writes the opinion. And he's shown a history of some creative rulings that get to an intended result of where he aligns himself with the more conservative justices, gets to the intended result here, permitting this specific religious school while minimizing the disruption to the broader sector. Chief Justice Roberts has shown a history of as kind of Eric flagged in some of the oral arguments discussion in some of the amicus briefs, highlighting the chaos that could go into the education sector and the charter school sector. Chief Justice Roberts has shown a history of being shy towards that. So we could see some kind of middle road ruling. We're not really sure what that could be. That could kind of split the difference and either deny this school but open the door in very limited circumstances where a religious school could open, or approve this school but in such a way where it'd be really hard for any other school to meet this specific criteria he had. That one's hard to project, but you could see it based on the Chief Justice's history and his political leanings and his history of kind of being this pivot in this court.
No, thank you so much. And I imagine those who are listening in are also taking notes because obviously when the decision comes down in a month or so, and how the decisions come, and obviously all the things that you mentioned, we'll have to come back. And I'll mention this at the end. We'll have to come back and sort of walk through what this could mean, both to your point, to more litigation, interpretation at the state level, and the like. So thank you, Rick. I mean, in your recent piece, Rick, you talked about even another implication, but almost on a different level in many ways that really got my attention as well. In your Slate piece, Rick, you wrote that the central problem is that the educational institution in question, St. Isidore of Seville Catholic Virtual School, is not designed to promote liberal democratic values or e pluribus unum in a nation that desperately needs it. And so the idea that schools like this could proliferate with public funding at the expense of, I guess to your point, schools that do promote liberal democratic values. Talk a little bit about what this could mean moving forward for generations to come if to Jason's point, we come up with the worst case scenario as it relates to the work that you're doing with your project and what you write about?
Well, your question raises really kind of the ultimate purpose of public education. What are we trying to do here? And as Eric mentioned, I've written about Al Shanker, who was president of the American Federation of Teachers and first brought the charter school idea to the national stage. Really helped jumpstart it, and he, thought these were public schools and non-sectarian, and indeed part of the reason that he and Bill Clinton, President Bill Clinton, backed charter schools was they were an alternative to private school vouchers. But in my biography of Al Shanker, Tough Liberal, which is conveniently placed right above to the side of my head, in case anyone wants to rush to Amazon. Tough Liberal includes a story in it that Lamar Alexander used to tell. Alexander and Shanker and a bunch of other education muckety-mucks were at a meeting, and the president of Notre Dame asked the question, well, what is the rationale for public schools? Why do they have to be public? And Alexander says there was this long, awkward silence and no one knew exactly what to say. And Shanker stands up and he says, well, public schools are to teach kids what it means to be an American. And this is an idea that we're trying to develop at the Progressive Policy Institute with the American Identity Project that I'm directing. But Shanker meant two things by that. First, he meant that the chief purpose of public schools, in addition to teaching literacy and numeracy and preparing people to be good, productive members of society and the workforce, the primary purpose was to create good citizens so that we can preserve our system of liberal democracy for generations to come. Now, the mission of private schools private religious schools is different. So Saint Isidore says that its ultimate mission is salvation. And that's fine. I have no quarrel with their mission. But that's not what public schools public funds are supposed to be about, because people have very different visions of salvation. And so if religious schools are authorized, religious charter schools are authorized, that undermines really the very purpose of public education, which is the primary purpose, which is to teach the values in a liberal democracy. The second reason that Shanker talked about this idea of teaching kids what it means to be an American, the second concept, which is related, is that liberal democracy and the values that come from the Constitution and the Declaration of Independence are the central creed of this country that keeps us together. It's a force for social cohesion. So unlike most nations, obviously, the United States, people come from every corner of the world. Every imaginable race and religion and nationalities. And public schools, including public charter schools, have been the primary mechanism for holding us all together. And Shanker wrote about the idea of, if a Martian came to the United States early in its history and saw that people were coming from such different backgrounds, different languages, different religions, different races, that they would predict that this society would not survive, that there would be internal war between different factions and different groups. And he said, we don't think about it, but it's actually, pretty miraculous that didn't happen. And instead, we became a country that has its divisions, but ultimately is among the freest in the world, the wealthiest, and we held it all together. And that public schools, including public charter schools, are a big part of the reason for that. So I worry deeply that if the Supreme Court authorizes religious private schools to be eligible for the public dollars, that we will undercut those two central ideas behind public education, that the primary purpose is to teach liberal democratic values, and that the related purpose is to bring us all together, to keep us together as a society. And I think that's all at risk if the Supreme Court decides the wrong way.
Thank you, Rick. I want to try to game out how we can predict what's going to happen in a month or so with the decision, based on what we heard just a week ago. For those of you who may not have been following, just a week ago, the court concluded their oral arguments. And for those who don't know oral arguments, opportunity for representatives, the counsel for both the United States, who's Solicitor General, but also the attorney for the state of Oklahoma, to actually have a back and forth with the justices, to ask questions and to answer and the like. And those oral arguments for many people illuminated the divergent views of the justices, the liberal justices and the conservative justices, just from the questions they're asking and how they're responding. And so, Eric, I want to come to you first. What do the oral arguments, as you heard them, tell you about how you think the justices, particularly the ones that may be swing justices, would vote based off of what you heard?
Yeah, thanks, Chris. That's the key question that's in front of us now, and it's a difficult one. I want to say that the oral arguments are important, and they do give us some clues. But just to give folks a sort of a broader lens on everything that's before the justices. So the parties will have submitted briefs themselves, long briefs on sort of exploring the law and the history of these constitutional questions going back decades and decades. And then groups on that agree with either sort of side of these questions posed to the Supreme Court have the opportunity to weigh in. So we've talked about these amicus briefs that National Alliance has participated in, Access participated in, a whole variety of others have participated in as well. And there were more than 40 briefs, I think nearly 50 briefs across both sides that expressed a whole variety of different views as to sort of why the court should side one way or the other, either going deeper on the law or sort of exploring some of the facts or the history like we did, for example. So the arguments are a critical part, and it does tell you a little bit about, or maybe a lot about, what the justices are thinking, but there's a lot that's underneath that that sort of led to that point. So it's just sort of important to know sort of like the whole context. So anyway, so we'll have to wait for the decision to be sure to know everything. But that said, to answer your question, it seems that the three more liberal justices, based on their questions, so Justice Kagan, Justice Sotomayor, and Justice Jackson, sort of firmly on the side that charter schools are public and it would be an Establishment Clause violation to allow religious charter schools, because we could not have religious public schools. They asked the question sort of in a bunch of different ways, but like I think it became clear that they believe that Oklahoma could do this. These are public schools, and therefore could be non-sectarian in the same way in which district-run public schools, as we've always understand them, just cannot establish religion. Seems that, so Jason had noted before, there are only 8 justices that are deciding this case. Amy Coney Barrett, Justice Barrett, recused herself from the case. So 4 of the more conservative justices, so Justice Thomas, Justice Alito, Justice Kavanaugh, to be sure, and even Justice Gorsuch, I think to some degree, we think that they're more inclined to think that charter schools, at least their question suggests, is that their independence and the way in which the programs were set up, that these are set up by states to allow outside groups to apply and get effectively a contract to run a school, that independence applies, that they could be more private. Some of the questions sort of said, well, how is this different from other groups that help the government provide some service that the government provides in a bunch of different ways, whether it's sort of utilities or otherwise, in which we can all sort of imagine more private organizations participating in government programs, grants, contracts, etc. So the 4 more conservative justice, those former conservative justices seem to be asking questions or even making statements that charter schools looked a little bit more like private organizations. So if private, then the cases that have been decided over the last 8 years that have talked about religious liberty. So you may have heard some of them: Trinity Lutheran, Espinoza, and Carson versus Macon, 3 cases in a row that have clarified a little bit more about free exercise rights of organizations and individuals that are trying to participate in government programs and receive government funding. So they're sort of relying on those cases, and in which case those line of cases said that if a government program is offered to outside organizations, that the government cannot deny religious organizations from participating in those programs purely because they're religious. So we heard a lot of questions that were sort of, leaning to those cases. So, and Chief Justice Roberts, as Jason was talking about, alluding to before, was harder to read. Sort of, came out of the gate saying, well, this is sort of different than how we've thought about these cases in the past. And then he asked other questions that maybe suggested, like, well, maybe it's not so different than the Trinity to Carson cases, and sort of how does this distinguish from other cases where the Supreme Court has said, no, these are not government operators, government entities. It's a little bit harder to read. It's our understanding that he often comes to oral arguments with that sort of premise, a little bit harder to read. As Chief Justice, he's responsible for a whole variety of things about the court, the reputation of the court, how it's run, federal justice system. So his scope can be a little bit wider, and I think because of that, he doesn't always reveal. So we don't know where he'll land. It's worth noting that those 3 cases that I just mentioned, Justice Roberts wrote all of them, so he knows the law, and is interested in clarifying this sort of distinction between establishment clause and free exercise, or just sort of broadly about the rights that us and the country have as it relates to free exercise. But we don't know, for a variety of reasons, where he'll land. So, if it's 4-4, if Chief Justice Roberts is the swing vote, and if we get to sort of a 4-4 tie, then, as Jason said, the Supreme Court affirms the lower court decision, but issues no commentary, and there's sort of no additional legal analysis. And so it, pushes the question off. The Oklahoma Supreme Court decision will remain, and the question could come up again. But for now, it will sort of resolve the case for St. Isidore in Oklahoma as it is now. So again, can't predict specifically one way or the other, but we think it's close. A lot of questions and a lot of topics that came up that I think demonstrated that this is not an easy issue. Questions about creation, questions about control, that's sort of one test that they talked about. Questions about discrimination, that's another set of Supreme Court cases invoked. Questions about sort of public benefits, that's a whole separate set of cases that were invoked. So it's not a slam dunk. There's a bunch of things I think that the justices will tease out as they think about this before they issue their decision. So cautiously optimistic that charter schools will be declared public, as they always have, but no clear prediction as of yet, at least as we see it.
Jason, you followed the oral arguments. Anything that you heard surprise you or give you a sense that where Roberts or others may land?
Yeah, I'll try and run through, I think, 3 pretty quickly. First, I thought in wrestling with like the religious nature of this proposed school, the justices focused almost exclusively on like the curriculum, on like the religious aspects, on whether religious beliefs would conflict with the state standards. But it was interesting that the questions didn't really touch on the real or potential impacts of what it means to operate a religious public school on student rights, on employee rights. Like in this specific case, I mentioned up front, like the school's application openly said they would provide special education services only insofar as not contrary to church teachings. Well, what does that mean? And what does it mean for this school? What does it mean for other schools where beyond the curriculum, the operation of the school? So that was one that I thought was interesting, but it didn't get to that level. Second, going back to a little bit where I spoke about regarding the authorized position of the case, we really hope the justices read our amicus brief for a number of reasons, but one moment that really stood out was, I think it was Justice Alito, I forget who was asking about, whether the authorizer is actually there reviewing and evaluating the curriculum and the materials the school is using to ensure that they comply with the state standards. And the Oklahoma Attorney General's attorney basically said, like, yeah, that's the job of the attorney. And the justice was like, really? We're like, yes, that is the level of control and oversight that an authorizer has of a charter school that is vastly, vastly different than the level of oversight the state has of a private school. So that I really hope they hone in on, see how involved the authorizer is in creating and controlling the school. And third, and I think what gave me a little bit of optimism coming out of this was Chief Justice Roberts had a line of questions on, how could this case to be distinguished from a case called Fulton, which is a kind of another case that's a little bit in the line of those cases that Eric mentioned, but on a separate issue. That was a case involving whether Philadelphia could exclude a Catholic adoption agency from its foster care program. And in response to that question, the Oklahoma Attorney General's attorney referenced a lot of things that Rick brought up, those 8 kind of characteristics, and really, I think, got to the heart of the question. The heart of this question of this is that, charter schools as a policy idea are trying to accomplish the same goal as traditional public schools, as Rick has laid out. They're trying to do that in new and innovative ways. So, and that's laid out in the intent and the purpose and the language of every charter school law in this country, that they're trying to solve a state constitutional function in new and innovative ways, but with all those same rights and responsibilities attached to it. So gave me some hope coming out of that Chief Justice Roberts was really trying to look and see, like, how can you distinguish this case from this case over here, which is really the core of the issue.
No, thank you, Jason. Yeah, I mean, it's again, for those who I mean, you can still watch, I guess, the oral arguments as well, to go through them in advance of the decision to hear what we're hearing. Rick, you've been following this as well. What is your prediction on how the court will vote based on what you've heard, both written about, but also hearing about the oral arguments?
Yeah, well, I agree with Eric and Jason that, all eyes are on Roberts. We'll see what happens with him. He kind of gave hope to both sides, I think, with his questions. So we'll just have to see. But I want to offer something. I guess I've been pretty down this whole time. So let me offer one idea for hope. If there is a bad decision and the Supreme Court says, charter schools or private schools, you have to authorize religious charter schools. There was one moment in the oral argument that really grabbed me, that got me thinking about kind of a workaround for a potentially bad decision. And that is Justices Sotomayor and Kenji Brown Jackson offered a hypothetical question. They said, if government wanted to communicate or commission a mural on a government building, and there was a religious painter who said, I want to put these religious images into that, could the government reject that approach? And the attorney for the charter school board, James Campbell, said yes. He said, because that's the government is trying to speak its own message on its building. That's the quote. And he claimed the charter school law in Oklahoma, by contrast, gives broad autonomy to the schools to come up with their own mission. But it seems to me, ultimately, under that logic, what if a charter school law were amended to say that the applicant's school is free to identify a variety of missions, as charter schools do, but that the ultimate mission has to be teaching liberal democratic values that bind us together as Americans. I mean, that's the central premise of a lot of state constitutions. And would have to say that's the most important mission. Now, a lot of religious schools would say, yeah, that's one of our missions, but they're not going to say it's their ultimate mission. As I said, St. Isidore said its ultimate goal is eternal salvation. And actually, for many religious leaders, it would be sacrilegious to say that liberal democracy is the school's primary mission. When former President Joe Biden called the ideals of the America's founding document, the Constitution, Declaration of Independence, sacred, there was a Catholic priest who wrote a piece in the Wall Street Journal who said, America isn't sacred, God is sacred. Only God is sacred. So this would be a kind of a new test that would say, it goes to mission. What's your mission? Not whether you're religious or not. And not every religious school would fail the test. There may be some that say that's our ultimate goal, but and there might be some secular schools that would fail the test. But if government is, as Campbell said, entitled to speak its own message on its own building, to me that suggests that schools, public schools, should be able to or states should be able to fund public schools to advance their central message of the preservation of liberal democracy. So this is a possible way to address an adverse ruling in this case.
No, thank you, Rick, for that. I mean, and as you mentioned, we have to be prepared for sadly anything, and so to do so, to be fully equipped. Our time is short, and I want to thank you all for joining us for this amazing conversation with these experts who were able to talk about this from very different perspectives, but also to prepare ourselves for what could possibly come. And so I want to thank you, Eric and Jason and Rick, for joining us today. This was so important. I think we need to come back and sort of button this up once we hear from the Supreme Court and be able to talk about what their decision will mean for states, for charter school authorizers, for parents, for schools. This could have an impact not only on public education, but on just religion in general and religious institutions in this country. So again, thank you all for joining us today. Follow NACSA, the Charter Alliance, the work that Rick is doing and all he's writing about, and the Progressive Policy Institute and the Reinventing America Schools Project. Thank you to the 74 and to all of you all for joining us today. Have a great day.
Thank you.